Hello, my name is Diana Chavez. Thank you for joining our webinar. SunRay secures $10 billion annually for GCs, subs, and suppliers. We're a national construction document service. Today, we have a great webinar on lien waivers and releases by construction lien law expert Steve Marso. Without further ado, I would like to introduce Steve Marso.
Thanks, Diana. Hi, everyone. My name is Steve Marso. I'm an attorney in Des Moines, Iowa with Whitfield Eddy. And this is going to be the third presentation I've given in 2023 with SunRay. The previous two were contractual payment provisions and mechanics liens, and this third presentation is entitled Lien Waivers and Releases. So let's dive right in. We have PowerPoint, so I'll be flipping through the pages for you to follow. If you have any questions, here's a slide that shows you how to type in the questions, and then at the end, Diana will let me know of any questions and I can answer those. And if you would like to ask me a question outside of this presentation, my contact information is on the slides and you can contact me directly afterwards. But let's jump into the substance of the presentation. The first issue I'm going to address are lien waivers versus non-lien waivers. And the first item I want to discuss is a lien versus a non-lien depends on the ownership of the property we're talking about, the property being improved by the construction project. So for private property, a mechanics lien is a tool that's available for contractors or subcontractors and suppliers to secure payment for the work they do to improve that private property. Now, a mechanics lien is purely a statutory creation, and in Iowa, it's under Iowa Code Chapter 572. That's where you find all the statutory provisions governing mechanics liens, and then obviously there's court cases that provide opinions on some questions and issues that might come up with debates or disagreements on what the statutes mean. So you have a combination of Iowa Code Chapters 572 and the Iowa case law that provide the law here for mechanics liens in Iowa. Now, what a mechanics lien provides to a person providing work on a privately owned real property is actually an interest in that property, and that's important as we'll see, because it's different than federal projects and other public projects where you don't get an interest in the property. On private property, the lien actually gives you an interest in the property, and you can actually foreclose on that lien through a lawsuit. And ultimately, if you don't get paid voluntarily by the defendant, you can potentially sell the property to get paid. So that's how it works. Now, it does not apply to publicly owned real property. Okay, so that's important. So it only deals with private property. And in Iowa, a mechanics lien is available to general contractors, subcontractors, and suppliers of all tiers. So remember that, because that's different than other property we'll get into. Okay, now turning to public property and specifically federally owned property. Mechanics lien doesn't apply here, but rather the federal government has provided the Federal Miller Act as an available tool for payment to those who provide work on federal construction projects. And it's a purely statutory creation, similar to a mechanics lien, but it's under what's called the Federal Miller Act, and I provide the United States Code section there for you. Now, in contrast to a mechanics lien, it provides the claimant only with a claim against the general contractor's payment bond. So what a Federal Miller Act claim ultimately is, if you file it and file a lawsuit, is actually a bond claim. And if you prevail as a claimant, you get a judgment against the surety and the principal and the bond to get paid. It does not provide the claimant with any interest in the real property. Okay, that's different than mechanics lien, as we discussed. But it also does not give the claimant any interest in the retainage held by the project owner from the contractor. And we'll show on the next slide how that's different than what's called the Little Miller Act in Iowa. But another distinction I want to point out here with the Miller Act is it's not available to general contractors or to certain lower tiered subcontractors and suppliers. And there's a lot of case law that discusses what subs and suppliers have potential Miller Act claims, which ones don't, but just understand that it's not available to some of them, and then it's not available to general contractors. The next piece of property we're going to talk about is public property, but non-federal, specifically state-owned property, property owned by counties, public schools, and other public entities in Iowa. And it's the Little Miller Act is the tool available for payment for those who provide work on those projects. Again, it's a purely statutory creation, and it's under Iowa Code Chapter 573, which is the chapter right after the Iowa Mechanics Liens. So for Iowa Board of Regents, which governs the universities in Iowa, or owns the universities, there's another code section I note here that also applies. And what a Little Miller Act in Iowa provides to a claimant is a claim against not just the general contractor's payment bond, but also against the retainage that the public owner is holding from the contractor. So it's actually two different claims. So if you file a Little Miller Act claim, file a lawsuit, you're suing for the retainage being held by the owner, and if that retainage is insufficient to fully pay a claimant, then the surety bond comes in to pay the remaining amount. And so that's a little different than the Miller Act. Again, the Little Miller Act does not provide a claimant with an interest in the property, rather it's interest in the bond and the retainage, but not an interest in that real property. And the Little Miller Act is not available to general contractors or to certain lower tiered suppliers, kind of similar to the Miller Act. So now, why did I discuss the details of these three different items, mechanics liens, Miller Act claims, Little Miller Act claims, in a subject about lien waivers? Well, because the issue is whether or not a lien waiver document that says it waives only lien rights actually waives any claims under the Miller Act or Little Miller Act, or any other claims for that matter that aren't lien claims. And the reason that's important is because the Miller Act and Iowa's Little Miller Act do not technically create any lien rights. As we've discussed, you can't put a lien on that public property. You can't foreclose on a lien and sell the public property. So it doesn't create lien rights in that real property. Now, in Iowa, lien waivers are strictly scrutinized. And as I cite here, this case from the Iowa Supreme Court in 1991 says all doubts about the waiver must be resolved in favor of the lien, namely that they did not waive something. So based on that case, it's you know, there is a risk that if your lien waiver document only says it waives liens, that the court would say that does not waive any Miller Act or Little Miller Act claims. So my point is, if you're using the same lien waiver document on all your projects, private, public, and it only talks about liens, well, then you get in those public projects, you might, as a contractor, you might be in a situation where the subs are not waiving any claim rights. And so it's advisable to have a waiver document that includes a waiver of all of these things: liens, Miller Act claims, and Little Miller Act claims. Put it all in your lien waiver document, as well as a waiver of any other claims. For example, claims against the project's retainage, surety bonds, and any claims and rights against the general contractor, the surety, the project owner, and the property. So that's what I would recommend. That way you can use that document on any project and be secure in knowing that you're probably going to have a waiver of any claims or liens or rights that might apply to that given project. Okay, let's go to the next area, which is limitations on waivers. So under Iowa's mechanics liens and Little Miller Act claim statutes, there are no limitations on the ability to waive those liens or Little Miller Act claim rights. So contractual waivers, so if you have signed a contract and you waive your mechanics lien rights or your Little Miller Act claim rights, in Iowa at least, those are valid even if the claimant has not furnished any work yet. So that's important because that is distinct from the Federal Miller Act, which does limit the ability to waive Miller Act claim rights. And I've actually quoted the section out of the Miller Act here that describes what is required to validly waive a Miller Act claim. And it's three things. It has to be in writing, has to be signed by the person whose right is waived, and it has to be executed after that claimant or whoever's furnishing the work has actually furnished labor and materials. So it cannot be in a contract that a claimant signs before they start work. So if you include a Miller Act waiver provision in your subcontract, for example, and have the subcontractor sign that before they start work, that is an invalid waiver. And so the waiver has to happen after the sub begins to furnish labor and materials. So that's important to know on those Federal Miller Act projects. Okay, another area or an issue that comes up with lien waivers are conditional versus unconditional lien waivers. And conditional lien waivers are, as their name suggests, conditioned on the claimant receiving the payment described in the waiver. So if the claimant does not receive the payment, then the waiver is not effective. And I think we've all seen those and dealt with those. And then unconditional waivers are not conditioned on the claimant receiving the payment described in the waiver. So even if the claimant does not receive the payment, the waiver is still effective. As a contractor, that's probably a more favorable waiver to have for you, but for a subcontractor who's signing it, you typically would not want to do that. What's the case law in Iowa say about this? Well, as I indicated before, the Iowa Supreme Court has ruled that any doubts are resolved against the waiver, so in favor of the claimant maintaining the lien right. So here's some quotes from the cases. The waiver to be effective has to be clear, satisfactory, unambiguous, and free from doubt. And any doubt about the waiver is resolved in favor of the lien. And then further, in interpreting the meaning of the written instrument, such as a lien waiver, the court's going to give effect to the intention of the parties in conformity with the reasonable application of the circumstances under which the instrument was executed. So what does that mean? Well, it means that if you want to have an unconditional lien waiver, you have to be clear in your language, spell it out clearly and directly. And if you don't do that, and if the language in the document is ambiguous or unclear or doubtful, the courts are generally going to say that's not an unconditional lien waiver, it's a conditional lien waiver. And an example of this is in that same case where the court, in deciding that the waiver was conditional, relied heavily on the contractor's testimony that they merely intended those waivers to be receipts for partial payment, and that they did not intend to waive anything other than the right to claim liens for what they'd actually been paid. And so the court, based heavily on that, said, we don't find that these were unconditional lien waivers. Okay, the next section is entitled Preceding versus Prospective Waivers. Now the preceding waiver, you could maybe describe that as a retroactive waiver. I don't like to use that term because I think it has some other meanings to it, but the point is we're dealing with waivers for work that's performed in the past versus waivers that include work to be done in the future. So what I call the preceding waiver, those limit the waiver to work performed prior to the date of the waiver and do not apply to future work. So typically, progress payment waivers where it identifies, hey, I'm receiving payment in this amount for prior work performed, and I'm waiving my lien for that amount for that work. That would be a preceding waiver. And so any future work that claimant performs after that execution of that waiver does not apply to that. Now, prospective waivers are not limited to work done in the past. They also apply to future work performed. So if the claimant signs one of those and performs work after the date of that waiver, then the waiver applies to that future work. So what does Iowa say about that, at least the cases? Again, I'm going back to this case, the Metro Federal Bank case. Again, the same rules apply. If there's ambiguity about this, then it's not going to be deemed a prospective waiver. It'll be interpreted as a preceding waiver only. And so if a contractor wants to have a prospective waiver, they again have to use clear, express, unambiguous language saying that. And again, that same case, the court stated that the language used in the waiver that the claimants were waiving lien rights for work furnished up to and including the date of payment was a preceding waiver only. And that seems to make sense to me. That's what that language, I think, indicates. But the court also said that the language that they're waiving lien rights for work rendered or furnished was also only a preceding waiver. And again, I think that makes sense because that's words that indicate the past. The court said had Baker intended to waive subsequent lien rights, the waivers could easily have been modified to waive rights for work to be performed or for work performed hereafter. So that shows you, according to the court, that some language that someone could use to create a prospective waiver. But the point is you have to be clear and unambiguous with it or else it's going to be deemed to be a preceding waiver only. So I think we're going to get to questions. Before we get to those, take a moment to review us on Google. There's some information on that. And my next presentation is going to be in December. Here's some information on that. It's going to be on Little Miller Act claims. So I mentioned those here today under Iowa Code Chapter 573. So I'm going to be discussing that. So I think for now, I'm finished with my presentation. So Diana, if there's any questions, we can have those now.
Steve, I do not see any questions at the moment.
Okay, so thanks everybody for attending. I have my contact information here. So if you do have any questions about anything or want to talk about anything or email, just feel free to give me a call or an email. But until then, thanks again for attending and have a good day.
Thank you very much, everyone. Have a sunny day.